Your irresistible offer, it might just be irresistible evidence. And actually, I bet it is. If you're a coach, a consultant, a course creator, anyone that's selling a transformation, some sort of fabulous outcome, you need to hear this, because most of you are making offers that I could use to bury you in court and destroy your business. I'm Karam. I'm the battle-tested lawyer. I've been an attorney now for 20 years. I've put together deals. I've advised on offers, and I've destroyed business owners in litigation, in courts that you don't want to be in. And they made claims that they just couldn't prove. So in today's video, I'm going to show you exactly how a litigation attorney, somebody like I used to be, would take your irresistible offer and turn it into an irresistible lawsuit. Step by step, allegation by allegation. So you can reverse engineer it and make sure that your offers actually hold up when someone comes after you. Let's go. So Alex Harmozi tells you to paint the dream outcome, promise the transformation, make the offer so good people feel stupid saying no. He's totally correct, and I love the guy. It's great advice, but he's not telling you something that's extremely important. Nobody's teaching it to you, and that's how to make your irresistible offers legally bulletproof. So that transformation that you promised doesn't come back as a lawsuit. Now imagine this, you're a coach, a consultant, you've built a program, you're promising some kind of transformation. Maybe you help people make more money. Maybe you help them lose weight, you get six-pack abs, you help get them clients, you help scale their business, whatever. You've got testimonials, you've got a sales page, you've got an irresistible offer with a dream outcome, you've got a beautiful website, and your website has copy that's so beautifully written by AI that my client, your former customer, couldn't say no to the transformation you promised. And they paid you $10,000, whatever the amount is. It doesn't really matter, but they didn't get the result that you promised them. They want their money back, and you say no. So now we're going to court, and that's where dreams go to die, and I'm going to show you exactly how I would dismantle you and make your irresistible offer irresistible evidence for my customer client now. The first thing I'm going to do is I'm going to draft a complaint, and all I need is a good faith basis to make an allegation against you. And that's pretty simple. I don't need to prove anything yet. I just need enough to get through the courthouse door. I don't need any facts, they're allegations. And here comes the counts of the complaint. Common law fraud. You made a representation to my client, they relied on it, it was false, they didn't get the outcome, they got damaged. That's fraud. That's count one. Count two is consumer fraud under state statutes. Almost every state has consumer protection laws. You're a professional selling to a consumer. That falls under the state statute. The standards are higher for you. And with that comes treble damages, attorney fees. I'll explain that later. But count three is going to be deceptive advertising. Your sales page, your webinar, your VSL, your Instagram post, everything you said to get my client to buy, that's advertising. And if it's misleading, which I believe it was, that's a separate cause of action. Now, count four is going to be violation of FTC guidelines. Now, the FTC has rules about income claims, testimonials, and results that I bet you don't know. And you probably violate at least three of them. There's federal exposure there, so that's count four. Count five is going to be your standard breach of contract. You promised a transformation, you promised in the contract's ambiguous, or you made promises outside the contract and you didn't deliver what was said. So that's a breach. Now, count six is going to be called unjust enrichment. You took my client's money, they got no benefit of value, you keeping that money is unjust. Those are equitable remedies. And if the court finds that you violated that, they have to disgorge the enrichment. That's what it calls. And here's the kicker, you ready? With all those counts, we've got count seven. That's alter ego. And I'm gonna write something like, upon information and belief, you operate your LLC as an alter ego of your personal life. You commingle funds, you don't follow corporate formalities, you treat your business like a personal piggy bank, you haven't satisfied the factors of the court. Now that count is going into every single complaint I file, every single one. So that's at least seven counts to the complaint that I count there, some equitable, some civil in nature. I'll attach some exhibits, but remember this, all I have to do is have a good faith basis to make allegations. I don't even have to have any facts yet. And you know where I get the facts? In discovery. And this is where it gets really, really fun. This is what I love to do. Now, I've seen good entrepreneurs get absolutely gutted in this phase. Business owners, people, you have no idea. Not because they're bad people, but because nobody warned them what was coming, what discovery is, how it works. So here's what I'm going to do. If I represented your former customer, I'm going to subpoena every version of your sales page, every webinar recording, every email you sent to my client, every DM, every testimonial you use, and the proof behind each one. I'm gonna ask you for metadata, all sorts of stuff for your chat. So here's where it's gonna hurt. I'm gonna ask you for the data, the objective evidence that you had on the day that you made these claims to substantiate the promises. You said clients make 6 figures. Show me the data. Where is it? You said people lose 30 pounds. Show me the study. Show me what you relied upon to make that claim. What do you use to substantiate it? You said that your method works. Well, prove it. Where's the evidence that you actually had before you made the claim? And when you're sitting there in a deposition under oath, I can ask you, what objective basis did you have for claiming your clients would double their revenue? And you better have an answer, you better have evidence, you better have data, you better know the legal standard. And let me tell you, I bet you don't. And something like, I believed it isn't enough, my best clients did isn't enough, it worked for me isn't enough. It's not legally sufficient. So I'm going to also hire an expert, someone who understands marketing claims, statistical evidence, substantiation requirements, FTC guidelines, and that expert is going to tear apart every promise that you made, because I bet you didn't hire an expert to write your copy. Your entire marketing history is now open for inspection, ChatGPT and all that stuff. I can get that stuff. Your claims, your screenshots, every result's not typical you forgot to include. Let me tell you something. I spent years advising entrepreneurs in the energy industry, solar industry, you name it. I'd sit in investor meetings, pitches, valuations. I'd see it in court. You know what claims I heard all the time? We're eco-friendly. We save consumers energy, etc. We're the future of conservative energy. Our global footprint is X. And then I'd say, all right, sounds good, but where's the data? What's the objective basis for that claim? 9 out of 10 times, there is nothing. There is no data. Those claims are fraudulent. They're deceptive. No documentation, just big claims and hope. Don't do that. And if you don't have substantiation around investors, I'm telling investors to run away, because I've seen what happens in court when you make these false claims, and you don't want to be in front of a judge when that happens. So if you're an entrepreneur and you're actually learning something here about litigation you didn't know, please subscribe to the channel, hit the like button. I break down attacks like this literally every week so you can protect yourself, maximize the value of your business. So drop me a comment. Tell me if you've ever been involved in any litigation. Have you ever been deposed, gone through discovery? I'd love to know about it. So not only am I confident I'm going to build a winning case based upon the evidence I get through subpoenas and depositions, which you can't object to, I'm also going to get your bank records, corporate documents, your own admissions, which I'm betting after interrogatories, depositions, going through all your evidence, I can prove my case by a preponderance of the evidence. That's only 51%. It's not beyond a reasonable doubt like a criminal case. And if you've got an LLC, I'm making a motion to the court to pierce your veil and hold you personally liable. But you're thinking now, I have a contract. They signed it. I'm protected. Well, let me tell you why your contract is probably going to make things worse in this scenario, not better, because I have a whole different argument for that. First, the presumption against the drafter is always on you. You're the professional. You drafted the contract. My client is a consumer. So any ambiguity in that contract is interpreted against you. That's called the presumption against the drafter. It's a rule that judges have to follow. Second, if your contract is ambiguous, and I guarantee it is because I'll prove it is, because that's what I do. You promised a transformation, but you didn't really define it clearly. You promised support, but you didn't specify what kind. You promised results, but you didn't clarify whose responsibility it was to achieve them. I can always find ambiguity. That ambiguity opens a door. It's called parole evidence, and that's a legal term that's really important. It's way above most people's heads, but here's what it means, and here's why you need a litigation attorney to protect your business. I get to bring in evidence from outside the contract because of parole evidence, because you were ambiguous. Those emails you sent, those DMs, those things you said on the sales call, those promises that aren't in the written agreement, because your contract was ambiguous. The judge lets me bring in all that extra evidence and representations to clear the ambiguity or to supplement it. That's evidence. Evidence of fraud, perhaps, evidence of misleading claims. You didn't even know that. And third, you didn't shift the legal burden properly. Your contract should make crystal clear that the client is responsible for their own results no matter what, really. That you make no guarantees and that the outcome depends on their effort and their implementation and their circumstances, not on yours, and that you waive any liability as such. But your contract probably says something soft like results may vary. That's not good enough, not in court, not in litigation. I'm gonna blow right through that. And fourth, your contract did not adequately limit your liability. This is huge. Now, with several counts of my complaint that include punitive damages, treble damages, that means 3 times the amount, and attorney fees, your exposure is significant and you can get your veil pierced. So no, your contract won't save you. In fact, I'm going to be attaching it to the complaint as Exhibit A in my case against you. And guess what? The court doesn't sympathize with business owners. I don't know if you know that. They stand up for the consumer. They're required to. They're not business friendly. and they're in fact overly protective of the consumer. And this is where most entrepreneurs get it completely wrong because they want their day in court, and you know what? You really don't, because it gets really ugly. Because when we're in front of a judge, after months of discovery, tens of thousands in legal fees, 1,000 pages of document disclosures, more than that, depositions where you had to explain every claim you ever made. I went through all your financial records. I turned your business inside out. Imagine standing there while I make this argument, knowing that I've got the evidence to back it up and I know everything about your business at this point, because that's what we do. I say, Your Honor, this defendant made material misrepresentations to induce my client to purchase their coaching program. It's that simple. They had no objective basis for their income claims. Their testimonials were misleading. Their contract was drafted to obscure, not clarify, and it was loaded with ambiguities. They violated state consumer protection statutes. They violated FTC guidelines. They violated the common law, and they operated their business as an alter ego, commingling personal and business funds. And I'd further add, and this is the kicker, that since the defendant did not act in accordance with the FTC's best practices and that they misrepresented facts, they had what's called unclean hands. Therefore, any legal defense that they're raising is null and void because they didn't come to court with clean hands. And because I proved consumer fraud under a state statute, I get triple damages. That's 3 times the amount. Your $10,000 refund just became 30 grand, plus you're paying my fees, and they're pretty expensive. You're gonna pay for your lawyer, my fees, punitive damages, anything the court wants to add to that. And plus, now, if I've proved that alter ego claim, your LLC protection's gone. I got your house, your savings, your retirement, your car. It's all fair game. And here's the worst part. If there's fraud involved, and there usually is like this, that judgment doesn't go away in bankruptcy. It sticks with you forever. Fraud is forever. That's what happens when your irresistible offer meets somebody like me, a vicious litigator, and I turn it into irresistible evidence. Now, with that said, here's the one thing that's going to save you. I don't want to win these cases anymore. I'd rather lose and help someone like you. I did enough damage, because when I lose, or somebody like me loses, it means somebody like you built their offer the right way. So let me tell you how to make your irresistible offer legally bulletproof. That's what this is all about. First, substantiate your claims before you make them. If you're going to say clients make 6 figures, have the data and have it before you make that statement. Document it. Data stamp it, right? Keep it forever. Because if I ask you in a deposition, you better have the receipts and you better be able to talk about it. And if you're relying upon an expert for your claims, you got to bring them to court and have opinions and records that you relied upon. Number 2, fix your contract. You need clear disclaimers, no guarantees. Results depend on client effort. Shift the burden of outcome onto them, not you. That's really important. It's what a lot of people miss. Disclaim the presumption against the drafter. It's devastating in litigation. Include a strong entire agreement provision. Make it airtight. Make sure your contract's not subject to parole evidence. Number 3, clean up your marketing. Every testimonial needs context. Understand the FTC. The results not typical isn't optional. Bulletproof your offers. Substantiate your claims and implement FTC best practices. That's probably the best thing you can do. Put together a legal compliance system. The same way that you systemize your emails and your funnels, you have to do that on the legal end. Trust me, it's going to help you. 4th, separate your business. Capitalize your LLC properly. Don't commingle funds. Follow corporate formalities. Understand LLC compliance, because I'm always going to allege alter ego. Always. Make sure I can't prove it. Number 5, document everything. Your sales process, your delivery, your client communications, your refund policy. If it's not documented, it really didn't happen. And trust me, have a third party look over your documents, an attorney, an accountant, what have you. Use professionals. 6, get yourself a relationship, like I said, with a battle-tested business attorney that can help you prevent your mistakes before you make them. Have the right accountant. Have them on speed dial. Trust me, they're worth their money in gold, but make sure they have real courtroom experience when it comes to an attorney and business experience. Because if you find yourself in court, and it's likely you will, when somebody like me comes after you and you've got proper substantiation, proper contracts, proper disclaimers, proper structure, I've got nothing. You've rebutted all my allegations and I can't build the facts in your case, then I'm gonna have to dismiss the claim. Otherwise, I look unreasonable to the court, and your attorney's probably gonna file that motion anyway. So if the judge sees a legitimate business, proper documentation, clear agreements, there's no fraud, there's no deception, there's just a client who didn't do the work right, and I don't dismiss the case, then then they're gonna look at me like the bad guy, not you, and you'll win over the court. That's the only way to do it. And that's the last resort, because I prefer to win the war without the battle, at least the legal battle. Remember, your irresistible offer can still be irresistible. It just needs to be legally bulletproof too, not evidence. Don't let your best marketing become your worst evidence. That's the worst thing that could happen. So if this opened your eyes, please subscribe to the channel. Drop a comment with any question you want me to answer. I literally read every comment. So if you want to find out now if your business is legally exposed, and I bet it is, take the risk report. It's a $7,500 in-person mastermind that I would charge you individually, but it's free because I trained the AI software to basically be like me and to give you the recommendations and action plans you need to get your business legally bulletproof. It's literally 5 minutes. It's free. It shows you exactly where someone like me would attack you across the 7 danger zones. I'm Karam Nahas, the battle-tested lawyer. Remember, defense wins championships. Get legally bulletproof.